the June 5th Scott County Board of Adjustment meeting. First item on the agenda is approval of the May 1st minutes. Has anyone had a chance to?
I'll make a motion to accept.
I second.
All right, motion's been made and seconded. All in favor say aye.
Aye.
Motion's passed. Second item, if everyone's had a chance to sign in, Charlie, can you swear them in, please?
Yeah, if everybody can stand, please raise your right hand. Now, see if this side of the room is behaving. Why can't you guys? You swear affirm the statement you make today to be the truth, to the best of your information and belief. Thank you all.
All right, thank you, Charlie. All right, old applications, I'm not showing any. We'll jump right into new, but before we get started, just a reminder, we have a full room tonight. Let's just wait our turns. Let's speak when you're called on, and don't talk amongst yourself, please. Thank you. Mark? First is S 2025-14. Staff will present.
Yes, good evening. My name is Mark Carper, and I'm pleased to be before you tonight to present the application for 95 La Costa Drive. This is for a conditional use permit for the operation of a pet boarding facility and a grooming business as well. For the first to be application as a kennel, the second as a home occupation. Figure out how to advance these. Okay. So the property is zoned A1 and is 5 acres. And we are recommending approval for this application with some conditions listed toward the end of this presentation. This is the site itself, an aerial view. Shows the main structure and the entryways that are possible on the outline of the parcel itself. It's another view of the neighborhood and one of the access points that could be derived. Uncertain as to when that might be utilized from the previous application. I understand that that was proposed not to be encouraged, may encourage from the main road. For conditional use permits, those are uses which are essential to or would promote the public health, safety, or welfare in one or more zones, but which would impair the integrity and character zone in which it is located or in adjoining zones unless restrictions on location, size, extent, and character or performance are imposed in addition to those imposed in the zoning regulation. Conditional uses may be permitted in districts as designated under the zoning district regulations, but only when specifically approved by the Board of Adjustments. These permits are subject to, at minimum, yearly review by the staff. A conditional use permit is legal authorization to undertake a conditional use issued by the administrative official pursuant to authorization by the Board of Adjustments, consisting of 2 parts. A statement of the factual determination by the Board of Adjustments which justifies the issuance of the permit, and a statement of special conditions which must be met in order for the use to be permitted. Section 412K of the zoning ordinance lists kennels as a conditional use in A1 zoning district. Kennels are defined in section 2(1) as follows. Commercial business for the sale or temporary boarding of 3 or more dogs over the age of 6 months, not including those owned by the resident or property owner. Section 256 gives the performance and design standards for kennels. They should be designed according to the following guidelines. All buildings and areas used in whole or in part for a commercial kennel, including animal runs, shall be a minimum of 100 feet from all property lines. All animal runs, exercise yards, or any outside used area for the kennel shall be located on the property so as to minimize any off-site impacts, including but not limited to noise. The Board of Adjustments and/or Planning Commission may direct the location of such areas as part of the conditional use and development plan, respectively. All animal runs, exercise yards, any outside area used for the kennel shall be fenced to ensure that no animals may leave the site. In addition, any outside uses, any areas used in conjunction with the kennel must be screened by a row of evergreen trees no more than 30 feet on center. Any area where dogs are kept overnight shall be soundproof to minimize any off-site impacts. All signage shall be reviewed and approved by the Board of Adjustments as part of the conditional use request. Applications for conditional use approval shall state the maximum number of animals to be kept on site. This is a closer view of the home. The area you see defined there is proposed outside exercise space for the dogs, the run itself. Here's another view of the structure. You can see some of the parking that's available, as well as some of the nearby residences with this area. Here's a view of the house itself from the front. There's the parking area we saw from the aerial view previously. And one last view of the parking area and the houses to the south. So in terms of the business plan for this proposed operation, they're as follows. They're in two parts. One for the kennel operations and secondly for the home occupation. For the kennel operations, dog boarding, its proposed hours of operation would be from 8 a.m. to 8 p.m. Each day of the week. Overnight boarding for up to 10 dogs, with 2 additional dogs being kept on the premises for daycare only. Expected duration of a stay for one dog may range from 1 week up to 10 days. A maximum number of drop-offs and pickups per day for boarding purposes expected to be limited to no more than 3. 10 individual closures to provide a safe and secure environment for the dogs, as well as food, water, and bedding, are located in the basement of the principal structure. An outside run, which you saw earlier, is about 3,362 square feet. It's enclosed in a 6-foot-high fence. The proposed dog run appears to be within range of 45 to 50 feet of the property line. This was my assessment based on looking at aerial imagery. The applicant states that the dogs will be under supervision at all times when kept outside. So this is the business plan for the kennel itself. For the grooming operation, they're as follows. The proposed hours from 10 a.m. to 6 p.m. by appointment only. No walk-ins would be accepted. Groomings would be 1 dog at a time with a maximum of 3 grooming clients per day. It's estimated the total maximum capacity of dogs on site for boarding and grooming would be no more than 14. Here's some images of the proposed operation or place of operation. This is believed to be the reception area for bringing in clients. To the left, you see the grooming area. This is one of close-ups of one of the sleeping quarters or enclosures for the pets or the dogs. So sorry. And we're done.
Yes, let's all go home.
Okay, thank you very much. I don't know what happened. Give me a second here.
You're fine.
Okay. Sorry. Okay. Bear with me.
Brett, is his mic on?
It's not for amplification, it's for recording.
Okay, that's what I was wondering.
These microphones don't amplify.
I mean, I can hear him well. I just didn't know about the room.
He said, ask him to
Okay.
speak up. You can't
Thank
hear
you very much.
You can't hear him?
I can't either.
Okay.
Mark,
Okay.
would you speak
Speak
up,
up a little
please?
louder.
Yes, yes.
That doesn't amplify. It only
It's
records.
all up to you, Mark.
Is this better? So this is a image of the closures where the dogs would be kept periods during the day and overnight. This is a portion of the outside run. I think this is when you first exit from the building, looking to the left. Here's a view of the extent of it, and here's a view to the right to the rest of the backyard of this particular property. After conferring with Scott County Animal Care and Control, there are no limitations on the number of animals that can be housed or served as long as a facility that can house more than 10 animals must be operated under a conditional use permit with an active LLC. So this is for a number of 10 dogs. If you had 10 dogs, more than 10 dogs, you'd have to be registered as a kennel, get a use permit. To use it as commercial, the Planning Commission defines kennels as a commercial business for the sale or temporary boarding of 3 or more dogs over the age of 6 months, not including those owned by the resident or property owner. So this is a definition by which we are making a decision or making recommendations in this application. Animal control does not have a required metric ratio for the number of staff the kennel must employ as it pertains to the extent of the operation proposed. These operations and others are subject to inspection by animal control and care as deemed necessary. It's unclear if there would be additional staff for this operation. So it's something that the applicant might be able to speak to. So the findings are that the project site is 5 acres, zoned A1. Access to the site is through a developed medium-density neighborhood. Section 412 of the zoning ordinance lists kennels and home occupations as conditional uses in the A1 zone. Furthermore, Section 2.56 provides specific design guidelines for the operation of kennels. The applicant has indicated that up to 3 client trips per day to the site may be generated by the proposed activity. Strict adherence to design guidelines for kennel operations reduces the impact of the conditional use on adjoining property owners. Without compliance with the zoning ordinance, approval of the conditional use permit would adversely impact public health, safety, or welfare and would alter the character of the general vicinity. Staff recommends approval of the request for conditional use permit for home occupation with a grooming business and a kennel for dog boarding business at the at the property address 95 La Costa Drive. Should the board approve the application, staff recommend including the following conditions of approval. The property is subject to all requirements of the Georgetown-Scott County zoning ordinance and subdivision development regulations. The applicant shall comply with all requirements of federal, state, and local regulatory entities. The applicant shall provide copies to the Board of Adjustments of all permits issued on behalf of the applicant as a result of this approval, including but not limited to business-related certifications, licenses, regulatory permits, and any recertification when required. The applicant shall submit a minor development plan for the project site in compliance with the design guidelines for kennels outlined in Section 2.56 of the zoning ordinance. Business operations shall not occur on the property until such time that the Planning Commission staff approve the minor development plan and all requirements have been installed according to said regulations. Per the design guidelines for the operations of kennel, all structures associated with the activity are to be a minimum of 100 feet from all property lines. Site plan showing the location of existing and kennel-associated structures and the respective distances to property lines is required. Property perimeter landscaping shall be installed along the south, west, and north property boundaries. And for the landscaping to adhere to standards set forth in Landscape and Land Use Buffer Ordinance Section 6.12.2, or a 15-foot wide buffer area with one tree per 40 feet of linear boundary plus 6-foot tall hedge, wall, or fence. The minor development plan for the property shall include the required boundary. Any areas with existing planting shall be reviewed to ensure the intent of the noise and light reduction is accomplished, and the Planning Commission staff reserves the right to require additional landscaping to achieve this condition. Per the Landscape and Land Use Buffer Ordinance Section 6.3, number 1, vehicular use perimeter requirements, a 3-foot average height continuous planting shall be installed for the parking facing south toward White Oak Village. Waste generated by this operation shall be collected daily, contained and disposed of in a manner that will prevent any off-site effects. The applicant shall provide details to how this waste material is to be contained while on site and how and on what schedule it will be removed from the site and to where it will be taken. Hours of operation shall cease at 8 p.m. on any given day. No more than 14 non-personal dogs should be on the property as part of the commercial activity. No more than 10 non-personal dogs shall board overnight on the property. The applicant shall not exceed 4 dogs outside at any time. There should be no allowance of animals outdoors without proper supervision and containment. There shall be no more than 3 grooming appointments per day. The applicant shall return to the board prior to any changes in the approved conditions. Failure to comply with the conditions of this permit shall constitute a review of this application. And this is one last view of the property itself. Okay, thank you very much.
I have a question before I pass it to questions from the rest of the board. This application, we have heard this application before, as we're all aware of. I know I saw a change from 30 dogs to 14 dogs. Is that correct?
Yes, we're treating this as a new application.
I know,
because
but
it was
I'm
planned-
just-
Yeah, so the proposal is for 10, maximum
Okay.
of 10 for overnight boarding, with 2 additional dogs for daycare, possibly.
Okay.
So the idea is at any one time, day or night, there would not be more than 14. There would be a maximum of 10 staying overnight, based upon that boarding, but 4 on-site non-owner dogs, or dogs not owned by the property owners themselves, no more than 10 overnight, is my understanding.
Okay, and also, and like, I know this is a new application, but I did see that the hours were changed. They did adjust their hours to a shorter time than
I
what we
believe
have
so.
heard before.
Yep.
Is there anything else distinctively changed from the last application to this application?
I think maybe more detail on terms of how the dogs would be managed and how separation between grooming operations and the kennel operations.
Okay.
So
Elaboration just on.
yeah, the
okay.
by appointments, limit to grooming kinds of restrictions. I think that's a new presentation or new information.
Thank you. Does anyone else have any questions for Mark at this time?
The dogs will be unattended.
I beg your pardon?
The dogs will be unattended outside.
They will be attended to.
Attended outside
Yes.
at all times.
Yes.
And I also noticed in the maps that section 2.56 required it to be 30 foot with greenery, I believe is what it said, or landscaping, and I've got a map up here that shows it 32.75. So is that a violation?
I don't understand
You
about
put
the
that in
landscaping.
the new conditions if we were
So
to
is that,
approve.
that's what I'm saying, is the
It will be
buffer
held
gonna
to
be
it.
changed?
If I understand correctly, the designs associated with kennels does specify evergreen trees 30 feet apart. We're proposing a different landscaping because this is a commercial operation, and what we're proposing is that any commercial operation next to residential have a more robust landscaping. So that's what we're proposing, that this be sort of addressed as though it was commercially zoned property. It's not zoned as such, but it is a commercial operation, and the property itself is relatively small. So that's one of our recommendations.
Thank you. Anything else? No? All right, that's all for now.
Okay.
Is the applicant here? Are you going to speak, or?
I'm going to speak on behalf of the applicant.
If I could ask you up front, please, the same question I'd asked Mark, could you just, before you start, summarize the changes between this and the old application?
Yeah, I'm gonna.
I'd like to introduce myself first.
That's fine.
Andre Regard, I'm an attorney. I'm here on behalf of the applicant. The changes that Mark went through are the changes that have been made. We have communicated with the planning and zoning staff in preparation of this application, and since the application was submitted, and we're very happy that the staff has recommended approval of this 2 times in a row now. Of course, the reduction in the number of animals is one of the issues. The reduction in hours is another issue. However, we do have a few comments on the staff recommendations. One, compliance with section 256 prior to operations. We currently believe that the applicant, as submitted, and the additional materials that were provided, particularly the photograph that you can look at, indicate that the applicant has already complied with any requirement under 256, and really that this Board of Adjustments today can approve the application as written without any further need. One, the issue about everything needs to be at least 100 feet from the property line. I don't know what map you're looking at, and I don't know if you're going to share that with us, but it turns out we did have the contractor out there today, and the back corner of the run fence, which was originally put up when they thought there would be 30 dogs, is less than 100 feet. So the contractor is, if we get approval today, which hopefully we will, the contractor tomorrow, or certainly by the end of the weekend, will take that fence and make sure that it's 100 feet from the closest line being the back, looking at the map, the back left-hand corner of the map. So we would ask that, with the exception of the fence being moved in order to comply with the 100-foot setback, that this Board of Adjustments today can approve everything. There is an exercise yard that's going to be supervised. I also want the board to appreciate that the sleeping areas and resting areas that were provided in the photograph are in the basement of the house. So this is not a function that's taking place in a auxiliary building somewhere on the 5 acres. This is actually in the house. Ms. Queen will be present in the house. This is a home-based business that she chooses to operate for a variety of reasons. So as far as where the dogs are kept overnight, being soundproof to minimize any off-site impacts, being that Ms. Queen and her family, her children, her husband live in the house, they certainly have no interest in having excessive dog noise, certainly nothing that any neighbor would hear. And specifically on the issue of soundproofing, there are no requirements of a definition of soundproofing. So I don't even know how the Board of Adjustments would be able to quantify that issue. The maximum number of dogs, as we've asked for, it's 10 overnight and 14 during the day. So one issue that we would take exception to from the recommendations of the board, of the staff, is their recommendation 3, based on compliance with section 256, as I just described. In section 5, the question about perimeter landscaping. I have some additional photos, but I think the photo that staff provided certainly shows that there is a tremendous amount of trees that already exist around the house. So one, the dogs, and the picture was provided, the dogs will run in a fenced-in area that is a privacy fence. So it's at least 6 feet tall. It's a privacy fence, board by board. Secondly, I think when you look at the photo, you see the privacy, you have the house, the privacy fence runs along the side and the back. What you see on the right-hand side of the photo is a playground for her children, and that is behind the house to the rear right of the house, which is even further away from the neighbors. As you can see from the photo, there are fences all around the actual homestead. The second exception we would take as it applies to that is on the front where the parking area would be, and if you look at the photo, you can see the driveway in the front. There already is a line of trees that run along the road. So to have to put up another hedge where the cars are parked, when you can't even see where the cars are parked because of the line of trees that already follow along the road, we believe would be a duplication and unnecessary expense that is not required for her to, for the applicant to have to comply with. Finally, on section 6, per the landscape and land use buffer ordinance, section 6.13, I'm sorry, that is the section that addresses the 3 feet. So section 5 is the general perimeter landscaping. We believe that's already there. You can see that on the photograph. We believe that the 6-foot-high privacy fence, which runs along the left-hand side of the house, which would be closest to the left neighbors, and along the back, certainly provides that additional view shed buffer. And then on section 6, where the staff has recommended an additional 3-foot-high continuous planting, we would ask that the Board of Adjustments waive that requirement, since, as you can see in the photo, there is already a hedge of trees along the road which block the view. So we would ask that the Board of Adjustments approve this conditional use in an A1 zone. It's an agricultural zone. It's not a commercial zone. A kennel is a conditional use that was contemplated at the time of the ordinances being passed. This certainly qualifies within the requirements of the kennel. It's going to be less than 50% of what was previously applied for. We do have a couple of customers and members of the community who know Ms. Queen and have used her services or are aware of her business that would like to also make a statement if the board would like to listen.
I've got a question I'd like to ask. Is she already in operation?
She is in operation, and since the last meeting, there was a condition that because dogs had already been scheduled, there were communications with Mr. Holden and Ms. Queen, and she was able to work through that schedule of dogs that had already been planned to go on the property.
Charlie, what about that? If she's already in operation after we denied her first time?
Well, that's just a matter for your all consideration. We do not have a rule that says they can't file an application while they're doing business, even if it's in
Violation?
in the face of a violation of the ordinance.
I have another question for you, Charlie. So I've asked both the lawyer and the staff about the changes from the first time we heard this, and I understand this is a new application. I'm totally aware of that, and I understood the staff sees the justification, and then us hearing
Well,
this
that's
is a
not
new
really the issue. The
application.
issue is it substantially the same application?
Yeah, so that's what I was gonna ask. So
Even if it's a new one.
the only thing they've really pointed out has been the number of dogs and the hours of time, which when we denied this, a lot of this was due to just the suitability of it, the proximity to the residential, and that's not changed. So is this, do we have the right to say that this is not a new I mean,
Well, first off, you're the board, I'm not.
okay,
But if the board feels that this is substantially the same application, albeit with some smaller numbers, then the appeal time for the last decision is over, and they really shouldn't be here. That's if the board feels this is substantially the same application. And if that's so, then, I mean, the board can make a motion, state its reasons why this is the same application, and move that basically we're not going to hear this. And at that point, They still can't appeal the original decision because time for that is 30 days and that's up. They can certainly appeal your decision not to hear it this time because it's already been heard. Now, probably the first thing I really should include in this, we don't have a rule, a specifically adopted rule that says they can't come back. But the law is on conditional use permits and pretty much any other action of the Board of Adjustment. They have a right of appeal under a specific statute, and it's to the circuit court, and it's within 30 days.
Okay.
That's not what this is. Statute doesn't provide for rehearing of a denial, any more than opponents could come in and say, I want a rehearing, on your approval. The statute provides one appeal that goes down there, and that time is up. So basically, if that's what the board wishes to do, then it would need to be a motion that we've heard this. It is substantially the same. Their time for appeal is up. This is not an appropriate method of appeal, and as such, it's not properly before this board. And then if that passes, then they're gone.
And then they would have placed an
But
appeal.
they could then appeal that, because
Right,
I think
but not
that
to
qualifies the final action, and they could appeal that.
Okay.
And then the circuit court would either say, Perkins is full of it, or I think that's correct, or something in between. I don't know what they would say. But I think that's certainly your option, because it was not appealed, and this certainly appears an awful lot like the original application.
May I address that point? There is not a provision for time periods between applications in Scott County. There's no time period that says when an application could be resubmitted. So,
And that is
No,
correct.
you can resubmit, but he's saying as a board, we have the decision whether we think this constitutes us hearing it again as a new application.
I understand, but I want to make my record.
Yes, yes.
There
That
is,
is true.
there is no provision. So when it comes to the point of whether or not it's a rehearing of the same application, it's not relevant because there's no provision that says what time period has to expire before an application can be made. You just don't have that provision.
Right.
Secondly, at this point, you've already taken testimony. So I would argue, just as the board's considering this, that you have already put yourself in a position that you are hearing this. If you had chosen not to hear it, then that should have been stated by the Board of Adjustments before staff made their recommendation. And you should have chosen that you did not have jurisdiction. I would just like to make my record that you did not have jurisdiction to
Charlie,
hear
I
it.
can't choose whether it's new until they have a chance to tell me if it's new.
No, but understand, the gentleman's making his record,
Okay.
and that's what he's required to do.
Gotcha.
And of course, that's what his client wants him to do.
Right.
But the counter statement to that is, you could not have done that until you had some basis on which to
Right.
do it.
Right.
The only way you have a basis on which to do
Is
it
to hear
is
it.
you appear here and you get a presentation and you say, well, wait a minute, that's the same one. Otherwise, you would be making a decision based on something that's not here on the official record. You can't do that.
That's what I thought. All right,
And
so-
I would address one other point. I would argue it is a substantially, since you are focusing on that issue, don't look at where it's located. It's obviously in the same place, but it is a substantially different application. 30 animals versus 10 animals overnight. And when you talk about commercial use, I'm kind of surprised that it's even addressed as a commercial use. You're talking about animals that are hopefully going to be there for multiple days, so you're talking about 2 or 3 cars that may come in, maybe a grooming dog now and then. That's a pretty substantial difference from saying we're going to have 30 animals there. It's a vet clinic that has a reception area that's going to have multiple people that are scheduled throughout the day to come in. So I would argue that it is a substantially different application.
Well, Charlie, I've stated my opinion. Do I just open this up for a board discussion? Because I don't know how they
Open
feel.
up for discussion and see what the board
Okay,
wishes to go.
Open for discussion, a motion, whatever y'all feel.
I think we've already heard just about everything already, on both sides. I make a motion to not hear the hear us 2025-14 at this time.
And I would ask that you include in your motion the reason for that.
Okay. It's
I
fair.
know you said we've heard this before, but
Yes.
I'll say specifically,
It's
you
very,
find
very similar
The
to.
present application is substantially the same application as we've already heard.
Correct,
And if that was going to be
For
appealed, it should have been
information.
appealed.
correct,
And this is not the appropriate.
correct, that's
place
what
for
I'm
that.
saying, yes.
Oh, I thought that's what you're saying.
Okay, a motion has been made. Do I have a second?
I'll second.
Motion been made and seconded. All in favor, aye.
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 Motion, aye.
All four?
Motion passed. Okay, thank y'all.
I have a question. Can I just say something before I leave? And it's not to get you all to change your mind, it's to make my name clear in the community.
Well,
That's entirely.
The motion's been made.
I mean, we voted not to hear it. I don't know if we want to
No,
continue.
that's fine. I need to talk to them, not you.
Okay, thank you.
Is this normal? Is that normal to get that?
If it's so ple-
Yeah.
if it so pleases the board, we may take a 5-minute intermission to allow for people who are wanting to leaving without interrupting the rest of the applications.
Thank you. All right, we're going to adjourn for 5 minutes and take a break. We'll meet back in 5 minutes. Yeah, 5 minutes, please, just 5 minutes.
It's fine. I have posted us later.
He's like, all right, guys, we're gonna proceed,
Cutting
please,
wood.
with the agenda. If, staff would represent, go ahead and present S 2025-15, we'll continue.
I'm back.
Thank you.
It's not every day you get a chance to discipline your third grade teacher. So I had to jump on that. Love them dearly. So anyway, now for something completely different. We're out Skinnersburg Road here. It's 2025-15 is the application. It is also, again, thank you, Ms. Rebecca. It is a conditional use permit again as well. This one is to prepare and package food products for off-site sales. Again, per usual, we are in the A1 zone, out Glass Pike towards Skinnersburg. Overall, staff is recommending approval of the application. I'll be real brief. This is the property here in question. And Mark has done a great job previously explaining conditional use permits, their role in our zoning ordinance and the economy at large.
And you're not going to repeat on that?
No, Mark did great.
Thank you very much.
Mark did really well.
You did.
So again, section 412 of our ordinance does list home occupations that exceed the limitations and the definition of such as conditional uses for consideration by staff and the Board of Adjustment in the A1 zone. They are all, again, defined in section 2.1 of said ordinance. It's a small personal service or operation in-home, little to no staff, minimal traffic, things of that nature. Limitations on the size and scope of the operation, 25% of the ground floor area and no event to exceed about 300 square feet. The home occupation on its face should present no outward evidence of an operation. The allowable signage is very minimal. At this time, there has been no signage or anything of that nature proposed. I believe the applicant has even stated that, very few shipments or deliveries coming or going, no on-site retail sales, things of that nature. The applicant has made their intention known that they hope to produce and sell products at farmers markets, small street fairs, things of that nature. Very boutique, I forget the phrase, artisan, something of that nature, beef jerky. While we do hope they're successful. So again, seems like impact from this use should be minimal, if any. Again, it is an application we're recommending approval of, as it does satisfy the intent of the ordinance. And I'll entertain any questions, but honestly, the applicant is probably better suited than me.
I've got a question for that.
Okay, and our conditions of approval are limited. There are 3 standard conditions of approval, essentially, for conditional use permits in the A1 zone. Essentially follow our rules and everybody else's, and then if anything changes, please come back to us and notify us when and if the property is ever sold or transferred. That does void the permit as well. Okay.
Anyone else have any questions for staff?
Not for you, right?
All right. Is the applicant here?
Yeah.
Would you like to add something?
All it is basically, we call our place JD Ranch.
Please step up.
I'm sorry.
You're fine.
We call our place JD Ranch out there. It's just a family get-together place. And we used to do crafts, we're at craft fairs and stuff. And now the wife is fixing to retire from Toyota. So she's just trying to supplement an income. And so we're not doing retail, we're just doing like car shows, farmers markets, little stuff, little craft shows or something, nothing on a big scale whatsoever. Just a little bit to keep her busy during her retirement, to kind of draw some income. That's all it is.
Okay, where do you get your beef? On 9 acres, I'm sure you can't.
No,
We have 5 cows.
We go to Sam's Club.
Oh,
We just
okay.
order it through Sam's Club, so it's all
Okay.
USDA meat. And like I say, it's just on a small scale. She's been selling it at her work, to people in her group, on a small scale. But she figures once she can get it going, maybe
Good idea.
do the car, because we do car shows, we do craft fairs and farmers, just small stuff like that. Nothing on a big retail. We don't even plan to go that big because we're not that smart to go that big. So, but that's all it is, just a supplemental thing for the income. So.
All right. Does anyone else have any questions? In that case, I'll entertain a motion.
I'll make them. Charlie, you see any problems or anything?
I do. It's not in not in stamping ground. Like, it's not in the city.
It's a long
our
drive.
fault, right?
Everything okay with you? Okay, I'll make the motion to accept or approve application number S-2025-15 for conditional use permit to package food products on Skinnersburg Road, and that is with the 3 staff recommendations.
Motion's been made, I need a second.
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 If I could ask for one change, just make it subject to staff report, because that'll have the findings in it.
Subject to the staff.
And condition, it'll have all of that stuff in it, and that way it's all incorporated.
Then just add it in your minutes.
Very good.
We still second it.
Good luck.
Yeah.
Right. All in favor say aye.
Aye.
Aye. Motion's passed.
While I'm sitting here talking and jabbering, who seconded it?
Both of us.
They kind of both did, I think it was first.
Yep, stop anytime.
Thank you.
Thank you.
All
Me
right,
again? It is me again.
all right, moving along.
Yeah, when I get to call Charlie's office, it's me again, Margaret.
That's
So,
good. It's USA.
A little bit different here.
Hopefully that means-
We're out on Triport Road now. It's a variance to reduce the front yard setback for accessory structure in the I-1 zone from 50 feet to 13 feet for the construction of a parking canopy that also incorporates a solar array. Again, it's a little unusual because it's an I-1 zone outside, in county jurisdiction. 5-acre site. Overall, we are recommending approval of this application. Here's the site in question. As you can see, there is already some solar infrastructure on the site. The installation of this additional would not constitute a conditional use permit or anything of that nature. It falls below the threshold that would mandate that. The zoning ordinance does have different tiers and things for solar arrays, and we'll get into that a little bit later as well. Something that Mark didn't do for me, so I do have to read all of this, is the state statute to which we're bound for the review of variances and their granting. Before any variance is granted, the board must find that the granting of the variance shall not adversely affect the public health, safety, or welfare, will not alter the essential character of the general vicinity, will not cause a hazard or nuisance to the public, will not allow an unreasonable circumvention of the requirements of the zoning regulations. In making these findings, the board shall consider whether the requested variance arises from special circumstances, which generally don't apply to land in this vicinity or same zone, that the strict application of the provisions of the regulation would deprive the applicant of the reasonable use of the land or would create an unnecessary hardship on the applicant, and whether the circumstances are the result of actions of the applicant taken subsequent to the adoption of the zoning regulations from which relief is sought. Board shall deny any request for variance arising from essentially circumstances that are the willful violation of the zoning regulation. The area in red there highlighted is the existing parking that they propose to cover. Again, the parking is there. This is not a new phase of development where they're adding additional parking that would kind of create further obstruction. Per our zoning regulations, this property does have landscape screening that projects out, already further than a canopy will, if so approved and installed. Again, just a little closer here. I don't have the math in front of me, but again, the size of this array does not constitute any further permitting other than the allowing of the variance. As you can kind of see there, there's the hedgerows and things of that nature. And again, this is the row of parking that would be covered. The screening there that is already installed creates sufficient separation from the roadway, protection from line of sight, and again, the canopy would not protrude any further into the right-of-way than landscaping does currently. Just a few more views of the property here. So the applicant has provided some justification for the granting the variance that staff does find that satisfies KRS 100-243. Although the proposed site is only 13 feet from Houston Drive, which is considerably less than a required 50 feet, it does not appear that it will create any traffic obstructions. So again, it will not adversely impact the health, safety, or welfare of the general public or the vicinity on its whole. We've already talked about that the parking and such is existing to include landscaping. Let's see here. We've talked about whether or not it'll create any additional visual obstruction. It is going to be an open-sided canopy to staff's knowledge. So line of sight should not be affected in any way. It just creates a cover over top. The applicant may speak more to that. Toyota has put out a carbon neutral initiative, essentially, that the applicant has stated that they would like to use this infrastructure to continue their compliance and completion of these goals. So staff feels that denying them the ability to use their property in this manner for responsible renewable energy and accomplishing these green initiative goals would create a hardship, and they would not, again, be able to fully meet the carbon reduction without utilizing this area due to the production that they have on site, their carbon footprint and stuff they create. They would not be able to mitigate it without further infrastructure. Again, staff does find that the statements made do satisfy the requirement of the statutes. And furthermore, to get even a little deeper, the comprehensive plan does encourage the adoption of renewable energy to include solar. It supports the expansion of solar and other renewable energy sources throughout the county, while also minimizing impacts to prime farmland. Section 253 of the ordinance again outlines the expectations for solar installations. Again, just double downs on the encouragement of appropriate siting of solar systems to bolster the local economic development and job creation, diversify the state's energy portfolio, strengthen energy and grid security, and reduce other environmental impacts, which again, the applicant has stated that would be the general purpose of this structure. We've gone over pretty much all of our findings, but we'll reiterate the reason for the variance application is that the setbacks for all structures to include accessory are 50 feet in the I-1 zone. This would constitute a 13-foot setback, I believe, from the nearest property line. Section 253, again, outlines the requirements and standards for solar. Granting the variance would allow the applicant full use of their property to achieve the goals of the section of the ordinance as well as the comprehensive plan, and also that it would positively impact the health, safety, and welfare of the immediate vicinity by providing shade that mitigates heat island effects that are generated from absorption of heat by impervious surfaces, the paving, the cars, et cetera. Learned a lot about that at a conference recently. And again, the statements provided by staff's determination do meet the justification needs of KRS. So again, overall, we are recommending approval of this application subject to our 4 standard conditions of approval. Follow our rules and everybody else's, obtain a building permit for the structure. Please come back to us if anything changes with your concept of development. You just wait till you hear about cool summer 2050.
Wow, that's just crazy. Oh, dear, 2050.
Maybe not on the board.
Does anyone have any questions for staff? You do?
I do.
Okay.
Is there a decommission, like end of life plan for, because
For this,
I know that I'm
for this
familiar
scale
with solar.
of operation, the ordinance does not require it. However, the contractor or supplier for the system may have supplied the applicant with a plan. Again, the size and scale of this does not meet the requirement for that in our ordinance. Pretty well any size that requires a conditional use permit, that would be a condition of approval at that time.
So it's not in our
They have not met
concern.
that threshold
Okay.
yet.
And have you all discussed any like routine maintenance for these structures?
I'll have to defer to the applicant on these things. But yeah, pretty well anything below 2,500 square foot, that may actually be different for the I-1 zone. I know the next application we're discussing, the tiers are, if it's more than 2,500 square feet, up to 10 acres, which is pretty broad. There are, at that point, do begin certain requirements. But I'll yield to the applicant for that.
Okay. Is the applicant here? Thank you, Red. You've heard a couple questions. Do you have anything else to add?
On the topic of the front yard offset of 13 feet versus the required 50 feet, we, as you can probably see on the map, we have tri-quarter as our primary road frontage. Houston Drive is our side road frontage. Houston Drive is basically a dead-end road. It goes into a handful of other businesses, one of which is Georgetown-Scott, which is our parent company. Part of that is it's all local traffic. It's nothing that's through traffic, so it's not. That's why we were deeming that as not really a significant impact to health or safety. As far as the decommissioning plan and so forth, we don't have anything specifically in place yet. However, we have been looking into. On our 2 current structures, we have already been looking into how to decommission the panels and recycle and so forth. And being part of the Toyota group and Toyota Susho, Clean Harbors and so forth, we actually had a few damaged panels during installation, and we're working through trying to.
That's what I was concerned about. In Florida, they're pretty standard in parking lots, the overhangs like that. I mean, of course, you've got a lot of sunshine, but they take a lot of weather
They do.
And, you know, the wind here is really crazy.
Yes.
But on top of that, when you have lightning hitting, it happens a lot.
Yes.
I do know this. And so you can end up having to go in with batteries. It's very expensive. Yes, it's,
Yes.
you know, it's clean and everything, but it's an expenditure too.
Yes.
Some people harness revenues, but like, I just wondered if you all had a plan for maintenance. I am sure that you're very responsible, that you're in an industrial district.
Yes.
And as far as I know, they're pretty responsible people out there. So, but like, I just wondered if that was on the radar to create that plan. That's why.
Yes, it is. We're working through that. And as far as, like you were saying, lightning strikes and so forth, structure are fully grounded. That's part of the electrical plan and design. And our electrical contractor handles that. So everything is done adequately for code. And as even decommissioning the structure, we've already considered that, because the structures, foundations are at grade. The structures are galvanized steel for maintenance and so forth, as far as maintaining, so forth. They're galvanized steel, so there's really.
Oh, I mean the panels themselves.
Right.
They have a
I'm just
lifespan
kinda
of like
walking through the
20
whole
years.
structure. So the structure itself is recyclable through metal recycling processes. Then the solar panels themselves and all electrical, solar panels there's methods to do it. And like I say, we're working through with Clean Harbors through Toilet Show and our contacts for that. So it's in process. So.
Okay,
Thank you.
thank you.
Is there any other questions?
I did notice power lines going across the parking lot.
Yes.
Okay.
I have already been in contact with Kentucky Utilities about the easement and spacing, so forth. And as long as we are with basically an imaginary, I think I can't remember off the top of my head. I think it's 12 feet they were requiring. As long as we're not within 12 foot, they were good. Because I sent photos and been in close communication with them a couple times. Management was considering doing this project a couple years ago, and then we backed off and waited, and now it came back up, and I revisited it with Kentucky Utilities, and they said they still have no issues with it. So, and I have no problem sharing the email threads and so forth if anyone needs to see.
Good question. Sounds good. Well, if there's no more questions, I will open for a motion.
Charlie, everything good with you? Any
I
concern?
have only one question. What's your name again, sir?
Jason Sammet.
Salmons?
Sammet, S-A-M-M-E-T.
Oh, Salmon. Okay.
Yeah. It's,
And that's my only question.
okay.
Okay. I'll entertain a motion.
I'll make a mo-
I'll second.
You want to
Okay.
make a motion? Okay.
I'll make the motion that we approve file number S-2025-16 for variance to reduce the front yard setback on Triport Road. I move that we approve that with the staff recommendations of approval.
Motion's been made. I'll take a second.
Yep.
All right. Made, seconded. All in favor, say aye.
Aye.
Aye. Motion passed.
Get your approval letter to you on Monday.
I just want to see it done
All right,
responsibly.
Rick, roll on.
Yeah, I think it's still me. Y'all want to, we can go back and talk about beef jerky again.
I wish you'd brought some, man.
Right. So, the new butcher downtown's got pretty good stuff too. I've tried it. We're now on Eder Lane. We're back in an A1 zone. Again, this application does pertain to a variance for a solar infrastructure. It's an 8-acre parcel. Overall, we are recommending approval. This one's a little different. It's like what I like to refer to as, again, a post-mortem variance. So the history behind this application is that, whoop, what happened there? That the original array you see there was permitted and installed at approximately 2020 at a time where, as we all remember, oversight and permitting and things of that nature was a little hit and miss. Again, they did receive the proper permits. However, to staff's understanding, the final inspections and things may not have been done. And through their application, through building inspection and ourselves, it has been discovered that the original array is actually not dimensionally compliant with our standards. So in their pursuit of adding some new panels on, and I'm not exactly sure if I've got my yellow rectangle where it needs to be, so please correct me if so, Before we can authorize the placement of any new panels, we need to make sure that the record is clear and that these are put into compliance. Of course, as we know, the state statute is pretty strict on granting variances. Staff has determined that, not allowing them or forcing them to remove these panels would create hardship. Again, they did go through the proper permitting processes at the time. I believe I've supplied the board with copies of the original permits, things of that nature. Staff has conferred with building inspection to understand that these are the circumstances. And so granting of the variance for the original array to make sure that they're now compliant will allow them to install this additional system. The new panels will be dimensionally compliant, so we're not going to create compounding dimensional variances or anything of that nature. It's just a little housekeeping here, keep everybody on the straight and narrow. As I mentioned before, the ordinance does provide tiers for solar arrays, and I'm sure I've got that in here somewhere. But again, so this array, the addition will create a total of 2,400 square feet. And yeah, again, we spoke anywhere between 2,500 square feet and 10 acres. You bump up to the next tier, which would require a conditional use permit. That was kind of initially on the table in the original proposal by the applicant, but through much discussion, they've decided to go below the limbo bar here and avoid having to get a conditional use permit, things of that nature, as those do become pretty restrictive pretty quickly. The conditions get pretty intense because, again, they're supposed to cover up to 10 acres of solar array, and they just did not deem it appropriate for their use. Let's see here. We've already kind of discussed this. Again, the comprehensive plan and the ordinance both do shake hands in their encouragement of the installation of this type of infrastructure. We discussed that previously. It's an 8-acre parcel. We're going to bring this structure into compliance and allow them to expand upon it within the limitations of the tier that they would be under. Again, about 2,400 square feet, keeping them below the threshold. Denying the variance would cause hardship, as it will limit their ability to fully utilize their property, or potentially cause them to have to remove things that's already been there that were technically properly permitted at the time 5 years ago. And beyond that, that's all I have for this application, except to reiterate, we are recommending approval. And again, this is just our 4 standard conditions of approval for a variance.
Any neighbor concerns or complaints?
I did have some, I don't exactly know, I want to say the person that called was on the north side, and they were pretty like, oh yeah, they've already got some, it's far away from me, that sounds good. So once people understand that this is like a, hey, we're just cleaning the house, we're not creating further encroachment, usually those concerns kind of go away.
Okay, good.
Sounds good for now.
Okay.
You got anything?
I mean, is there somebody here to speak on it first?
Yeah.
Is
Yeah,
there?
the applicant's here.
Is the applicant here? Would you like to add anything to his presentation?
No, he pretty well summed it up. As you can see, it's just the front corner. It was an oversight on our part, we try to color inside the lines. As far as decommissioning, there is a place that recycles solar panels in Georgia. So that is possible, if that is a concern. You just send them down there and they take everything out that they can recycle and take care of it.
Like stripping hardwood.
Is there a big energy savings on those solar panels?
Yes, ma'am. Of course, depending upon your electric bill itself, Mr. McCarty's electric bill will not be net zero. I mean, he's running this business and it runs for the business, not to his home, so.
So you lease that property from him to put your panels on?
No, this is his. He owns it.
Okay. Okay, well, I had somebody who raised serious concerns on the Soil Conservation Board with with basically them aging. I can't even speak right now. Yeah, degradation, thank you. I had a moment. And with it just going not maintained. And like, that's why I brought it up with the other proposal as well, because like I wanted to, it's basically because you're in an A1 area and you're surrounded by farmlands with wildlife. They brought up soil erosion, water contamination, the KRS's erosion control, water runoff, the EPA Clean Water Act, like I can keep going. And the National Pollutant Discharge, but the maintenance and the routine care and tracking of it, because when people have put these up in the past in other places, they do lease their land out, or,
Correct.
you know what that is. It's basically solar farming.
Right.
And so he wanted to make sure that when this is done, like if you all ever quit maintaining this, that it goes back to the integrity that was already there before those existed. Because if not, when they degrade, they have fibers, and like I worked in agriculture my whole adult life, but specifically I dealt with solar panels a lot and solar fence chargers of all sizes, gates, all kinds of things. They do, and like they do take maintenance. Janet knows this. Her husband, I used to have to wait on all the time, but they get hit a lot by lightning. But like you also have lithium in there, and so many things can happen. Is somebody going to take the time to make sure that, this new one is going
The
to?
biggest difference between what you're talking about with the chargers and stuff, there is no batteries.
Right, but the
there's no
panel
lithium.
itself, regardless, is just baking its whole life.
Right.
And
But
so-
these new panels have a 30-year warranty. and
Right, I
an expectancy of 50.
have that.
Charlie, is this under our umbrella?
I contacted Charlie today.
Yeah, it's a fine line. We
Yeah.
talked about it today. If she's simply talking about solar panels in general, no, that's not our
No.
authority at all.
This
If she's
one is
talking about
around the
these
area,
Installation
yeah.
of these, how will they be maintained, what impacts they're gonna have on adjacent properties.
Right.
And that
Because
sort of thing,
there-
if they're allowed to degrade, that.
There is
actually
wildlife
touch on us.
all the way around. Like the person I spoke with has a huge point, and like if they do degrade and that stuff goes out into, the landscape or the, I don't know, like the grass, the groundwater. Like I've heard it all today, specifically like the equine, but like there is a wildlife rescue there, and so like they're all concerned about maintenance, upkeep, and
Well-
so I just want to hear.
We maintain them. We put them, we install them, we maintain them. If Mr. McCarty sees anything going on, he calls us and we come out and
So
take
you're
care of it.
powering off of this? Okay, so if you're not receiving the amount of energy, then you would realize that something's wrong with it and it has lived its life, right? And so you will repair it, right?
Correct.
Awesome.
What is the lifespan on a solar panel?
So they're warranted for 30 years, but life expectancy, not,
20 to 30.
is 50 in Kentucky.
Well, 20 to 30 is like the general, like what I was handed for those panels, so.
Well, those panels are warranted for 30, so they're not gonna be.
I
end of life at
understand.
30.
Does it for a living, yeah.
Yeah, I believe. I just
Alright.
needed to ask those questions. Thank
Right,
you.
right.
Thank you. Now we all have a better understanding. Any other questions?
Good
You got
question.
anything else, hon? Anything else?
Mm-mm.
Nope. Nope. Anything? All right. There aren't any more questions?
Charlie, you good with it?
Oh, yes. Although I hate to admit it, but I've been trying to figure out where in the world it is on Header Lane. I've just been driving by there apparently or on my bike and not seen anything.
I can. I just had to bring it up.
Well, that's what I
Learn
mean.
something from it.
I'm gonna pay more attention next time. Hopefully I'll see something.
It's just the neglected ones. I think that scare
Yeah.
people.
Yeah. All right. I'll entertain a motion.
I'll motion
Okay.
that we accept the,
Application.
sorry, yeah,
That's
I'm
okay.
still thinking about those soil people. That we accept the variance to reduce the side yard setback from 50 feet to the 20 feet for the installation of small scale solar array less than 2,500 square feet at 391 Eder
There
Lane.
you go. With the staff recommendation.
With the staff recommendations accepted as well.
All right. Motion's been made. Second. Anyone?
Aye.
All right. All in favor, say aye.
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 Who did, Tom
Tommy.
did this, the second?
I did, I guess.
Oh, you did? I
Yeah,
thought
that'll
Tommy
work.
did.
Sorry,
Okay.
usually I'm more collected than that, but that was a lot to absorb
Okay, I'm stuck on
about
20,
a
30,
panel.
20, 50 still. I won't get off
Been
that.
around a while, it's still new.
I told them, it just scares people when they go neglected, I think. That was the basis of that.
Yeah.
Thank y'all.
Like the old fashioned satellites, do you remember? The big ones?
Still see
If you know, you
Well,
know.
and then my nephew's like, perhaps his job is they do all solar, because that's what he does at the state. So he's an electrical engineer, and he's switching out to solar at the state. It's
Yeah.
pretty cool.
It's getting more popular.
All right. Oh, hello again.
Hi.
All right,
No
moving
more
on,
solar.
moving on.
Our last application to review for tonight will be pretty brief. I apologize in my haste to get the PowerPoint presented. I left out the final number and the file number. It's 18, in case anyone's uncertain about that. This application is for a variance. They're requesting to reduce the 50-foot required setback for an ag land down to 15 feet, specific to one part of the property itself, although it be applicable to the particular property line itself. This is on Gaines Road. It's put forth by the Lewis family. I think it's Ronnie and Emily Lewis. As mentioned, the property is zoned A1. It's about 9.5 acres, and we are recommending approval for this application. This is a aerial imagery of the site. You can see that there are a lot of contour lines, and those contour lines are quite close to each other, with the exception of one small spot down in the bottom right corner, where I have a little drawn rectangle representing where the proposed house would be. There's a driveway that enters off of Gaines Road, goes along the right side of that property, the east side, as you can see, curves to its right, and then provides access to an adjacent property just to the south of it. So that is a shared access. The only other buildable spot on that property, other than where that house is proposed, would be on the driveway itself. So for that reason, they're asking for a variance because where they're proposing to put the home is closer to that southern property line than what is permitted by our ordinance. Rhett did do the honor of reading the details about variances, and I will spare you from me reading them this evening. So as mentioned, they are requesting a variance 35 feet from the 50-foot setback. As mentioned, it's a 9.5 acre property. There are no previous applications on the Board of Adjustments project site. The proposed home will be located in the place I had mentioned before, or shown to you on the previous illustration. It's the only flat area that's available for that particular slope. In addition, or sorry, for that property. In addition to the slope, there's a pretty sizable utility easement going across it, which is visible by that dark spot, as you can see, or dark line transecting the property itself. The findings are as follows. Mentioned the zoning and the size of the property, composed primarily steep slopes with the transcending utility easement, limited area of level ground, the 15-foot side yard setback the applicant seeks while not in keeping with the characteristic of rural residential areas not along the road front and would largely be unnoticed. I did receive one telephone call about this application based upon notification letters that were sent out, asking for details, asking about the location. They did not receive the map or the plat in those letters, but just basically described what was presented there. The home and the adjacent property to the south is approximately 235 feet from where the proposed home would be. So we are recommending approval with the following conditions as listed here. Some typical ones in terms of adhering to all the requirements for Georgetown-Scott County ordinance and development regulations, complying with all the other federal, state, and local regulatory entities, that they require a building permit for building inspection office prior to any construction, and if there's any changes, they should return to the board for approval conditions. Given the proximity of that home to adjacent property line and that it's a shared access to another one, something the board may want to consider is whether or not screening would be appropriate to shield the southern home from the view. I'm not sure if the applicants have any intention of doing that. It wasn't proposed, but something you might want to consider.
Okay.
Yeah. So I'm open for questions if you have any.
Any phone calls from neighbors concerning?
Just the one phone call
Just
I
the
mentioned,
one?
yes.
All right, any other for now?
I had a call as well. I'm not sure if it was the same person Mark talked to, but it was similar concerns. I believe they're related to the folks to the south. Just general questions about the application. I believe they may be to this team.
Great.
We're all here.
Okay.
Okay.
That's one way you guys are.
All right. Is the applicant here? All right,
Oh,
we
great.
might get back with you in a minute, Mark, if you'll step up, sir.
Okay.
you like to add anything to his presentation?
Well, the only reason I was trying to put the house there is because I was trying to rent a bulldozer because I was gonna do because there's an old house there, it's sitting there anyways. It has a cistern there and an outhouse, so it has like no electric, no nothing. I mean, it's very old. And I was gonna try to level the land off to put a home there because I walked out on the other side of the property and it's gonna cost like $5,100 a month just for me to rent a bulldozer. That's not including me having the fuel, having to have gravel put down or anything else. And we may run into this problem as well because of how the property line is and how this gentleman was talking about the driveway. It was brought up to me putting the trailer in the driveway, and I'm not gonna do that because that would cause more time and trouble for the neighbors because I don't wanna reroute it or anything. And if I did that, the trailer would sit right on the edge of the hill. And I have 3 young children. I didn't want that. That's why I was trying to see if this would get approved where I could put it in that little flat where my kids could have a little bit of a yard and they wouldn't be close to the edge of the driveway going over the hill.
So you're saying there's an old house footprint you're trying to stay in that area? Is that what you said?
Yes, ma'am, because we're getting a double wide. It's, I believe, if I'm not mistaken, off the top of my head, I think it's a 36 by 72. It's 5 bedroom where I have 3 kids and I do have family. Because I'm not originally from around here. I'm from Harlan County. So it's about 3.5 hours for my family to come up here. And we're getting a bigger trailer because where it was 5 bedroom, we could have an extra bedroom for them to come and stay all night and stuff. And we wanted to get out of the city limits of Georgetown too because I'm not used to having too many neighbors front, left, and right of me.
As long as you're outside the city limits, that's for sure.
Yes, sir, yeah. That's the only reason I'm trying, and I deer hunt, and I know
I was about to
with
say
that
this
much
looks like
acreage,
a hunting.
I could probably get me a deer.
There you go. Does anyone else have any questions for him at the moment? All right, you hang tight. We're gonna go to the other people, okay?
Yes, ma'am.
Is anyone else would like to speak on this application? State your name, please.
Katie Adams.
Okay.
Jean, I'm here to represent Jean and Jim, or James and Jim Gillespie, or Jean Gillespie on 1207. I have a little bit of a better map, if you would like to see, than what they showed of his property that he's talking about. And the area of the house that he wants to put is right here. This back land under here, which is not shown, is our property or their property. He wants to put it in this little corner. Here's the driveway that he is talking. Can I approach?
Yeah.
Here is his property. Here is the easement or the driveway that he is talking about that's been there.
The shared driveway?
The shared driveway
Okay.
that's been there for 50+ years.
Okay.
This is, so this back here is our property.
Yeah,
He
if you
wants
can
to
scoot
put
over,
his-
let me, because I've got to describe
He
all
wants to
this.
put, he would like to put, as far as I know, the house in this corner.
Okay.
Um,
And your objection is?
that well, a 5-bedroom, where's he gonna put the lagoon?
There are several, actually.
There's several reasons. This house,
That's the house he's talking about, the old
yes,
house?
the old house
Okay.
is condemned and has been
Right,
for
and he's
years.
taking it
And he's
out.
taking it
Mhm.
out, that's fine. But if you go 15 feet, either on this direction, it will be like where is he gonna, where are you gonna put your water, your lagoon? Is it gonna go over the driveway?
Yes, it's already.
Our water line is already there.
Well, that would have to be approved, not outside
yeah,
of
right.
us. Yeah,
That'd be
located.
that would be health department and all that would have to prove that.
Right, but before, wouldn't we have to get that information before we say, yes, you can have 15-foot variance? Wouldn't we
No,
wanna-
because they have to meet the conditions. If we allow a variance, then they have to meet the conditions and make it work, right?
And if the health department doesn't approve it, then
Then
nothing
he
happens.
doesn't-
anyway.
doesn't
Well, I
matter.
called the state, I called the county, and they said I needed to call the state. So I called Wedco here, and they said absolutely not, over the line 10 feet from the house, and 10 feet from the water and the sewer line.
Well, like I said, that would be outside of us, so, yeah,
Right,
yeah.
and they said no, so.
Well, I mean, like I said,
Right,
that,
right,
yeah,
right.
yeah. We
But
will,
here-
well, you know,
Here is the map if you want to.
we're not gonna override anything that comes
Okay.
out like that, so
Yeah.
don't think that we have that.
Okay, all right, so they might have more concerns.
Can you leave us that so we can
I
look at
can,
it?
there's lots of stuff wrote on the back and probably not spelled right.
Well, I'm just gonna have him look at it in a minute, so,
that's
okay.
fine. Yeah, he can address it.
Yeah.
He has some more information on the sewer as far as, or the septic and lagoon size. that needs to come with a 5-bedroom house, because we checked on.
Do we have to worry about that, like I said, if we do the
Well,
variance?
it's kind of a bizarre situation. We have no authority to do anything with on-site septic disposal, period. So if we approve a location and the health department says no,
It
well,
voids
then it
us.
doesn't happen.
Right, it doesn't happen.
It doesn't happen. So then we have to come back here, and all we can do is basically look at the topography and say, that is absurd to say, meet all the regulations otherwise,
Right.
because you're gonna be on a, something like that.
Right.
And I got to admit, I used to ride my bike on Gage Road.
Yeah.
I can't imagine not needing a variance to put something somewhere. I mean, that's just a wonderful bunch of hills. But all we do is. So for example, if we could look at a topo map,
Yeah.
and here's a flat spot, here's one, we're gonna pick the one that's the least encroachment in
Right.
setbacks.
Right.
If there are no places but one, but that's an old existing place, we've often tried to use that existing place, so we don't basically have a dead area where the old house was here,
Yeah.
and now we've got dead areas, where we're trying to make new ones. That's really the extent of our authority on this thing. And ultimately, whatever the health department says is really gonna govern, because if we approve everything and they tell him no, he's got to come back and start over
Like
again.
that line, like like our house, their house was like at the bottom, so that line, they're gonna put their house right at the top of our property and over our, he was talking about the driveway of some sort, if possible.
Well, like I said, well, basically, like Charlie said, we would just say, if this is the only way, we would give him the go-ahead, and then he still has to meet all. I do have a question for him, though, because it's not showing the house where the old house was. There's quite a bit of distance there.
Have the gentleman come
That's what I was wanting to verify.
I
Could you-
have all that slab, I already had 2 contractors come out and look at everything, already about dosing everything down, about putting gutters in for the house.
Yeah.
About digging the water line.
So it is.
Is that the old house?
Wow.
No, I guess my question is, this is showing that is this where you're putting your house in the
Yes,
garden?
ma'am.
Okay.
Okay, like, this corner's up, and then this corner's up right here. Like, the old house is pretty much sitting right here. Then you have the cistern behind it, then you have the outhouse, and then you have a little old building here. Yes,
Okay.
then it tapers down to where the fence is, where their driveway goes through.
This is the top of our.
Yeah, I think I've actually pulled it up on my cell phone.
That's okay. That's
I
okay.
actually showed you the actual house.
Get ready to go.
The driveway.
Glad we relaxed.
Been there for 50 years, driveway road.
Doug Adams.
Doug Adams
Yeah.
and Kim.
Okay, there,
But
Gene
you see what
Gillespie.
we're saying, like, it's like, even if we say,
On the other side of the driveway, as he's saying, it's a straight.
no, but I'm saying though, even if we approve it,
Doug
yeah,
Adams.
that doesn't mean anything if he can't do it.
Dean,
You're-
and I'm
If
Jean.
what you're told is right, then you're.
And Jim is over here.
But we
Not
have,
saying a word.
Charlie's just saying we have to give him the ability to try to use his
We
land.
don't want
Yeah, yeah, yeah. And then they'll work with him and, yeah. Okay. All right.
Okay.
Is there anything else from neighbors?
Could-
If you get that low,
do you have something?
Yeah, I wanted to say something.
Don't worry about
Okay.
it, that's fine.
So again, I'm Doug Adams, son-in-law. So the water line runs along that access. And that access, they've been there 50 years or so. That access keeps moving towards where he wants to build. So the water line is on the outside from his property or his house location.
Right.
But that driveway keeps moving that way.
you mean
And
like
they-
it's eroding?
It's eroding because it's a
Right.
hill like this.
Yeah,
And
it's,
so it is walking towards where he wants to build.
Right,
It
but a
has been.
property
Now
line
the
is,
driveway closer to
A
where
property
he
line.
is, basically.
Right.
a property
And
line
the sliver of
doesn't-
land that's left there, what he's talking about, I have to think that end of the house is gonna be right on the driveway
Right
as
on the
it sits.
driveway.
As
So
it
within
sits.
10 years, how you gonna get in there?
right.
'Cause
I
you can't-
understand what you're saying, but I also know that no matter what, like those stakes, like when a surveyor comes out, I mean, the pins, like when they come out, they don't, like, they'll go off of other things to get that. It won't change. Yeah, the road may,
He said he's already got it
but
staked out.
I have a question. Well, I'm saying the property though, regardless, if it's theirs, it's theirs. If it's his, it's
Right,
his, right?
right,
It
right.
stays.
Yes,
That
yes,
doesn't
yes.
change which way the road goes.
Yep.
Sounds like you gotta add gravel to another side.
We don't
But,
have a
If there's a house there.
right,
then we
I
can do it.
understand.
And I have to-
but the property is the property. So I have a question. Whoever has lived there, is it you, ma'am?
Yes, hon.
Were you there when the stick house was being occupied?
When the house there in the corner?
The original home?
Yes, there was a tenant, let's see, it was occupied for about 3 or 4 tenants, I believe. A lady named Parrish owned it, and she rented it out.
Like a boarding house?
No, she lived in town.
Oh, okay,
It was just a
okay,
rental.
Okay.
And it has been abandoned for probably almost 30 years. The cistern's completely,
Was it a
unusable.
nuisance to, like,
And the roof's
then?
fallen in, so it would have to be bulldozed out.
But the location and the people being occupied at that time, did it cause a problem?
No, it was further back.
No.
It's in the setback.
It's in, yeah.
Towards the other neighbor also.
Mhm.
Yeah.
But I do have a question.
Can we see it?
Yeah,
He's
that'd be
talking
great.
about, he mentioned the driveway,
It's better.
having to move the driveway. Can he do that if that's our only way in and out?
No. I'm not gonna touch the driveway at all.
Oh, okay.
Because the realtor asked me about that, and I said I would not do that, because where you all live up there, it would be an inconvenience for you all. I told them I will not touch the driveway at all.
Yeah, it would be more than an inconvenience, it would be impossible to get in and out.
Well, I had
We're
a
landlocked.
realtor and somebody else that works, I forgot who it was, they come out and we measured it. It's gonna be like 10 or 15 foot, how our measurements was from the driveway to the corner of the house. But where that house sits,
Is this the old house right there?
that, where that old house sits, is where part of the trailer is gonna go through, because there's a 5-foot oak tree there, and a locust as well, and I was gonna have all that tore out, and that's where I was gonna put the home.
So you are gonna somewhat share this old footprint?
That's what I'm
Yes.
getting.
Okay.
Yeah, because that's why I was getting rid of all of that
That's
stuff,
what I
is
was
I'm not gonna
thinking.
touch, I'm not gonna deviate anything on the driveway, because that's the only access they have to their property, so I'm not gonna touch anything of that.
But that would be
So he wants to-
We were gonna be building on the other corner, closer to us, not closer to the old house.
Oh, okay, I'll show you the map right here.
Okay.
Staff, is this what you saw?
Is he gonna overstep on the way the outer is?
Yeah, the previous plat on file does locate.
Y'all listen up, Brett's explaining.
Oh, I'm sorry.
The plat on file for the property does locate the existing house, as would a surveyor.
Okay.
So it is, whatever may remain of it, is a currently non-compliant structure that's not outside the boundaries of modern standards.
Okay.
Channing's point, and Charlie's as well, is, we try to not compound or worsen problems, but if it's an existing condition, and it makes sense on the property, per KRS, et cetera. Now, what type and orientation of house, that's up to your all's determination, and the stuff the applicants provided. Elise, is there a maintenance agreement as well? There shouldn't be a maintenance agreement on this plat, that should address some current concerns that we're having here in regards to access. Let's see here.
It states access there.
You're talking about access
Well, there should be a written agreement on here that we signed at the time that designates who's responsible.
I would have tried,
Yeah.
I would have tried to talk you out of it.
Okay.
Oh, I know. I understand.
All right.
It's done.
Right, yeah, it probably would be.
I hate that this is
Anyway,
uncomfortable
I'll
for
just try and
them.
help. Because typically, whether it be in the deed or reflected on the plat, there will be a maintenance agreement that originates from the creation of the plat and the easement that states property owners to the use of their extent are required to maintain it. The applicant, as well as the users to the south, would be bound by that as a legally binding thing. So the roadway must be maintained, and these folks would not be able to be legally landlocked.
Okay, so just to sum up what we've heard then, he has said that he is not touching the driveway. He is going to put his house in what staff recommends is the best, most suitable area to be able to use his land. Is that what staff has stated? And then as far as the concerns about the lagoon or any other sewer system, that will have to be approved. I mean, that's by health department and everything. So Is there any other concerns outside of those?
Just that he said he was gonna put it where the old house footprint is. It's in the setback to the side also.
He wouldn't need 15 feet if he actually puts it where the structure is.
He said part of it will be there.
Part of it.
It's
Right,
a
but
large,
he's-
it's a
He's being
large.
precautious.
He's not asking for access to that side, only to our side.
Right.
Yeah.
He's
You're
not,
saying, you're saying he needs to have two adjustments, is what you're trying to say?
Yes.
If he wants to put it.
Is that true?
It's not gonna fit in this triangle.
It's
Unless
not.
he goes into that easement also.
Okay, let's go back to staff. Staff?
Yes.
So the application showed the proposed home would require the variance only for the southern boundary.
Okay.
So the applicant, at least the communications didn't indicate that the existing home would be demolished and placed upon that. It was not what we need. If they are going to put it where it's shown there, they're going to need a variance for the eastern boundary as well. So it require two variances.
Okay.
What's the scale of that plan?
It's tiny.
I mean, it just doesn't look like that triangle's big enough,
It's
even
not.
with overlap to the south.
It's 256 feet from pin to pin, and if you take 50 off that side, you have 200 feet left, and the driveway is, before you get to the pin, and it's pretty far, and I would say 30 feet. So you're cutting down in 100 feet, and he's trying to put 75 feet in there, and be 10 foot off the driveway.
And,
It's barely gonna fit if it fits.
yeah, we had no idea where he was gonna try to put
But-
it or how big it was gonna
Right.
be. So,
The contractor I talked to, and I could put it under the hill, like if I put my trailer right here, it would literally go over the hill below my trailer in that little hollow.
For the lagoon.
For the lagoon, because they said he works for the city, where he, I forgot the gentleman's name, I think it's Kentucky something, but he told me that he would do all of it, like he said he'd done enough lagoons, everything, like Scott County, that he said it would be a waste, like, it would be, I put my house here, where you know where the big white oak is.
Oh, yeah, the very big white oak, the 300-year-old white oak.
Right-hand side of it, under the hill, he said it would be a way, nobody would be able to, it would be out of everybody's way, is what he told me.
So if we approve this application per what staff has said, then he has to respect that. He cannot encroach on another side without coming back to us for
Right.
another variance, and he's aware of that, so.
And I'm assuming that it's still a requirement when you go through building inspection, you're gonna have a layout shown on some sort of drawing.
Yes.
And if that drawing doesn't comport with what's approved here, then
You'll be
you can't
back.
put it in. You've got to come back and we've got to make adjustments, or might end up not being able to do it at all.
Now, like where the house sits right here, and the property, it's, like if you look at the screen, it'll be on your right-hand side. We've measured from that fence, the top of that fence with a 100-foot tape measure, and we marked off with a stick what would be 50 foot off of that property already. We already put little sticks in the ground, like just like a rough estimate of what we would need and where we could put the trailer.
So
And we approve what's been, assuming it's approved, then building inspection would confirm that, and they'd be limited to that, and if that works, then it works. If it doesn't, and of course, if the health department says no, you can still no.
That's fair.
And then if it doesn't work, it's gonna encroach some other, he's gonna have to come back, because he won't be able to do anything. So, it sounds like, I wish I could say it is, but it sounds like we've got this thing covered. But if it doesn't actually work on the ground, then you're gonna have to come back.
Right, I mean, if it doesn't work out, I mean, there's no hard feelings, it doesn't work out, it doesn't work out.
Regroup and try again.
Later on.
Yeah.
And then he would need to apply for the eastern boundary.
Yeah.
Yes.
Well, the
eastern
Cooks.
bound, that's where we are, literally, like, as I said before, we have measured off of that fence, and it was 50 foot. We already measured for 50 foot with the realtor. And we tried to stay within that 50 foot, but the one that's on the backhand side, which would be
I see.
the Gillespie's, that's the one we're needing.
The southern side.
Yes, the variance from.
Okay.
It's from that fence,
So
not
we
the
would
one
just
that
be
would be
approving
behind the house.
Can I
All
ask
right, then
him,
Charlie, if we have everything covered per this application, can I go ahead and entertain a motion per this application?
I think you can.
Okay.
And as I said, if there's a mistake on the ground, it's not gonna go anywhere. And if this is correct, then
No.
it looks like he can do, assuming the health department obviously approves his on-site septic disposal.
The neighbor has one more question.
the, I'm wondering why you wouldn't want that extra 50 feet. Why would you not want, I mean, if you're going to take 15 feet from the south, 35, excuse me, right. Why wouldn't you also want that other 35 to give you just a bumper of space?
Oh, she's wanting to move off the
Trying to
driveway.
set the trailer up, it's gonna be probably like 10 foot off the 50 feet from that fence, from the southern side. And then how wide the trailer is, that's how far it's gonna be away from your house fence on the backhand side.
Oh, I understand that, but I don't know why you don't want that extra space.
I think they're wanting you to encroach closer to them and come off the driveway, is what she's saying.
Well, yeah, because when I pull in my our driveway, it will, my car will be 3 or 4 feet from his house.
Yes.
It would be actually a little bit further, how we're trying to set it up.
Yeah.
We got the sticks, I mean, we were just doing a rough draft.
Yeah.
Should we let the neighbors go away and talk about this amongst themselves and then come back
Going
together?
through the veterans
Should we
association.
send them out to talk amongst themselves and come back again? They're wanting him to encroach farther away.
I don't want to squelch anyone's dreams, but,
Yeah, that's what she said, come off the driveway. She said, come on.
This way.
yeah, we haven't had a neighbor for 30 years, so we're a little concerned about having a neighbor in for on
Would you
the driveway.
like to have a healthy conversation outside of here before revisiting this?
We
No.
never met.
You all haven't had a
Well,
chance
no.
to converse?
No, that's okay.
Her husband, Jim, before he was going to grass and come up there on the riding wheel, right? So I don't know.
Oh, you did hear.
I think what they're saying is they would just like you to have that variance on the other side, so you're off of the driveway some, but that would require a second variance, right, from a different application.
Well, we'd rather.
Go ahead, Holmes.
Perspective, once an applicant has stated that they believe they could meet
Then we cannot
requirements
adjust.
of our zoning ordinance, and that is what the staff's recommendation would be. Again, as Mark and Brett have discussed, when an applicant can meet our standards without undue hardship or burden, then that is the expectation.
Okay, all right.
So that neighbor house is like 2,000
So then we're back
feet.
again to, I can entertain a motion
Nothing to
on
do
the
with that
application
neighbor.
as
They
is.
would not
Yeah, I make a motion.
respect
Yeah.
whatsoever,
All right.
which would help us a lot.
You have one.
I make a motion to accept S 2025-18 variance on Gaines Road from 50 feet to 35 feet.
No.
15.
15 to 15 feet.
Is there? No, it
Okay,
says- it
15
says
feet,
that-
I'm sorry,
Oh,
to 15 feet on Gaines Road.
35.
With staff recommendations.
With including staff recommendations.
All right, motion's been made, I'll take a second.
Second.
Motion's been made and seconded, all in favor, aye?
Aye.
Motion passes.
What's the use of having an ordinance that says if we're not gonna abide by it?
Thank you.
There are a lot more things that have to happen after this that aren't in our control.
I don't see that.
All right,
Understood.
thank you. So, you're good to go.
I mean,
Is there anything else for the meeting tonight, or are we officially
Staff has nothing further.
thank you.
adjourned?
No. I think that they needed
No, but like Colton said, if we